4, 3, 2, 1.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning to the parties, and we are delighted that you have chosen to be with us on this occasion to present your case under these circumstances as we are facing in our nation today. We will proceed as if we were actually in the courtroom. We will maintain a certain amount of order. Each party has been aware, I'm sure by now, of the amount of time that you have to present your case, your argument. We will follow that example. Also, if there's any preliminary matters, Mr. Clerk, before we proceed.
No, Your Honor.
In that case, will you please call the first case?
Michael Kevin Upchurch versus Sullivan County Department of Education.
Upchurch, we'll hear from you.
Okay, thank you, Your Honor. For nearly a year after I found and reported the black mold that was making me sick at Sullivan North High School, Sullivan County Department of Education intentionally and maliciously concealed my biohazard exposure, failed to remediate contamination of property, committed fraud and misrepresentation during my ongoing workers' compensation case, and intentionally slandered my name to staff and students, saying I was sick before I came to the school. I got the black mold elsewhere. I was just trying to get money. There was no mold in the school, and I didn't know what I was talking about.
Well, before Let me ask you a question.
Yes, sir.
You said during your workers' compensation case, had you filed a claim for workers' compensation?
Yes, I did, as the county instructed me to, and I filed a workers' compensation claim only to have the county withhold evidence from my workers' comp case that proved that the testing that they had done in the school was insufficient testing for the accurate results for the black mold that we were looking for. I'd already given them proof of a test that I had done of black mold in the school. And that was directly after I had been told that they weren't, basically that I didn't know what I was talking about and there was no mold. I was already sick in level 2 symptoms when I did find the mold. So after I found the mold, I reported it. I did a complete investigation, a prompt and proper investigation. Before I was a teacher, I was in construction for 25 plus years and a decade of that nearly as a construction manager. So I knew the procedures of what to do when you do find things like this in a building. And the county did not handle this properly. You're supposed to investigate it promptly and properly. You're supposed to document the premises, video, take pictures of all the site to what it looks like when the complaint was made. You're supposed to collect samples. If there's visible mold, you need to collect physical samples so you can test those and see what that mold is. You need to confirm what mold species are present when you take those tests. You also need to document the locations where that mold is found. You need to use a report with a scientific method that has the validity to test what you're looking for. And then you need to remediate that mold according with what mold species it is. If it's mildew, it's pretty easy to clean. If it's black mold in the situation like at North, it's a lot harder. So that is what happened. They did not do the proper remediation. Instead of documenting the premises, they chose to destroy all evidence, spoil evidence. They removed all signs of mold after I reported it. They turned down the air to lower the temperature down to get ready for a fraudulent air test, which they performed, which doesn't pick up black mold. And that's what they used in my case against my workers' comp to deny me any fair medical that I still have. I have asthma now. I have chronic sinusitis. I have a diagnosed mold allergy from a doctor. I have proof of black mold from the school from 2 tests taken from accredited labs from physical samples. Well, the school did an air test after they spent a month and a half basically spoiling all evidence of mold. They took all desks, all chairs, all carpet, all ceiling tiles, everything out of the classrooms where I was sick and replaced it with the new ceiling tiles in the ceiling, but they left the mold up above the ceiling tiles. When I found the mold found the mold in my original complaint when I was when moving resources from one classroom to the next. And this is a picture. I don't know if you can see it in your gallery picture, but this is how I found the mold. I was moving.
Is that picture, is a copy of that picture in the file, in the record?
This picture is just, I don't know if it's in the file, it was all these pictures
You
are.
know, we're all limited to what is in the record.
Well, it is in the record. I did take documents. I told that in my file, I did say that the next day after they denied that the mold, I came in and did documentation. So this is part of the documentation I did. I documented properly the premises, showing how I found the mold. How I found the mold was this ceiling tile was rotted out from water intrusion. Apparently the school, like the superintendent told me, of head of maintenance, had leaked for over 30 years. The school had leaked since it was new, and they had failed to remediate it in 40 years. Instead of, they had money allocated to fix the school twice and chose not to. So you had a school that was leaking water since 1980, and they put trash cans underneath the leaks to catch the water. And their policy for 20 years since they had mold in East, in a news report, was that they were a little more sensitive of the mold in their schools. Now they were told custodians and principals to replace ceiling tiles when they saw them discolored. So their policy has been to replace these ceiling tiles instead of properly remediating the leaks in their roofs. And that's what happened at North, which made me so sick. I was in a building that had been shut down for almost 8 months. And when they moved me to this classroom, because they were unable to heat the classroom I was in before, I got moved up to this warm classroom, which was nice at first, but then I became deathly ill. I didn't know what it was. When I found this mold in the ceiling, I mean, it was just growing right on the wall where the ceiling tile had been rotted out from water damage. It wasn't like I had to be a super sleuth to find it. Then after I found it and I went and compared it to the symptoms I was having, that's when I noticed I was in all of level 1 and level 2 mold poisoning. So I had just a few things left in level 3. I was starting to lose my long-term memory. The only other symptoms I had left were blindness, brain damage, bleeding lungs, cancer, and death. That's how sick I was. I had 4 doctors confirm the fact that I had a fungal infection. I had a mold allergist and pulmonologist confirm the fact that I had a mold allergy after being in contact with this mold at North High School. Testing I did was from Semi's labs. This is part of the record I turned in. I went to South Environmental Microbiology Laboratories in Greenville, South Carolina. This is a premier laboratory that all they tested at the time was asbestos and mold. They were a construction laboratory that tested physical samples of construction debris for testing for asbestos and mold. They did test it positive. The sample that I took was from a tile right outside of my classroom, which I was in the record too. I took this tile right here with the mold on it and had it tested. It tested positive for black mold. I returned that information to the Sullivan County School Board in the middle of March, and they still denied that there was any mold in the school, said they had no mold in the school, and they still continued to destroy evidence of the mold at the school while I was out, told me to take workers' comp while they continued to spoil evidence at the site and get ready for this fake air test, which they had done, which was done by Wingfield Environmental, which does all of their testing. Now, the thing about—
let me ask you one other question here.
Yeah.
What is your workers' compensation case? Is that continuing, or has the final outcome been reached?
Well, this molder test, when they after they spoiled evidence, then they brought in Wingfield to do this mold test. Wingfield did a air test instead of a physical sample. He did air test, and he sent off air cassettes from a company called San Air Laboratories. Well, the laboratory I used was, like I said, physical samples. This is air testing. So they're testing the air in the building. They're not actually testing any physical samples of the mold that was present. So what they do is they turn the air down below Sullivan County guidelines in their handbooks to get it down. Once you get the humidity down below 30% of the building, that's what you do when you get a flood in a building and you're trying to dry it out where you don't want mold to grow. You turn the air up and you get the humidity down. If you get the humidity down below 30%, it inhibits mold growth. Well, the same thing with these air tests. When they turn the air down below the guidelines, it also lowers the mold for air testing. It won't pick it up on air test. But that's the biggest problem is this air test that they did. What happened with workers' comp is they withheld 7 pages of the report that tell that basically this is what the part they withheld. This organism is rarely found in outdoor samples. It is usually difficult to find in indoor samples unless it is physically disturbed because it is spores are of a gelatinous mass, grows well on wet medium, permeated containing or perfectly containing cellulose. It proliferates in an indoor environment with long-term water damage growing on wallpaper, gypsum board, and textiles. As a general rule, air cultures for Stachybotrys yield unpredictable results. That's what their own testing said, and they withheld that paper from my workers' comp. They withheld 7 pages from it. When I informed workers' comp of this and was trying to get my appeal set, that's when workers' comp said this is no longer a workers' comp case. They informed me that I had a year time limit on my statute of limitations from the time I originally filed and told me this was now a court case. That's why I filed a court case in Sullivan County within my statute of limitations. Sullivan County is trying to say that this is a workers' comp case still, even after workers' comp has released it and said that it is a court case due to the fraud committed and the fraudulent testing that was done and all the other slander, the concealment. I mean, there's just a lot of things that add up that were all intentional. For one to be there would be, you know, kind of coincidental, but for 4 or 5 things to line up like this with the slander, with the concealment, with the spoiling of evidence, and within with this fraudulent air test. The lab that tested mine has one of 12 pages on the bottom. All 12 pages were turned over to workers' comp. In their case, they have on the bottom of theirs, it says 1 of 11, and they withheld 7 pages. And one of the pages they held tells that there's no validity in this testing for black mold. They've been cheating the system in Sullivan County for 20 years that I know of with this air testing. 4 teachers have told me similar situations. One at North High School, they reported sickness. They had mold in their classroom. They said that the county workers came in over the weekend when they don't even work, replaced all the visible ceiling tiles, and then a few days later show the teacher a mold test, say there's no mold in the building. What is happening is these teachers aren't aware of building procedures and the way that you deal with this. So they're turning over these air tests saying there's no mold when this air test is not a valid test. And they even withheld the pages that say it on my report, which is in the middle of the report, which is kind of it's kind of intentional, kind of crazy that this all lines up like this. So I'm in a catch-22. The laboratory that tested mine told me and a witness that that it was a good thing I brought in a physical sample because this stuff doesn't show up on indoor air samples. It's real sticky. It sticks to the walls. It doesn't get stirred around unless there's a disturbance, and it gets physically disturbed and lodged in the air cassette. Well, they tested it. The school's been tested twice. I tested with 2 accredited labs, and they both were physical samples tested positive for black mold. Within a year's time, 4 tests were done on the school. 2 by me, 2 by Sullivan County. 3 tests showed black mold. The school was finally shut down 5 days or 7 days after I resigned for my health. The school was shut down for mold remediation that they found on their own testing with these fraudulent air tests, which if mold shows up on these fraudulent air tests, it's really bad. The spores that I did were on tape samples, which showed 1,000 to 10,000 spores in 3/4 by an inch tape sample. The air test they found that they shut down the school revealed 8 microscopic spores, and still on the second test where they found mold, none of the areas where I was sickened were tested again. So this is why the workers' comp told me that this is now a court case, and this is why I believe that no government tort liability should protect. These are all intentional malicious acts that were performed on me. They killed the messengers, what they tried to do. I mean, I can't help it. I got sick in a school that they neglected for 40 years and chose to not remediate, instead to replace ceiling tiles. After a while, they quit even doing that. I mean, they would just put holes in them and let the trash cans catch the water underneath right through the mold instead of actually taking out the tiles and replacing them. So even after they failed to do proper remediation, they even failed to do what they were going to say, which was even not proper remediation by not remediating at all, just replacing ceiling tiles. And that's how I got sick, and that's where I'm at.
You have time for your rebuttal.
Okay.
Thank you.
Thank you.
Yes, sir. Mr. Street.
Thank you, Your Honor. I'm Dan Street, the county attorney for Sullivan County. Plaintiff in this argument is proceeding pro se, so I allowed him to have his say. But the issue here today is this complaint was dismissed for failure to state a cause of action, and the standard's pretty clear on that we're limited to what's set forth in the complaint. This case is a workers' comp case. This lawsuit that he has filed, the trial court found that this was not a workers' comp pleading. He found no claim for workers' comp benefits, and it was dismissed. The plaintiff admits in his complaint that he was instructed to take leave, which he did, and to file a workers' comp claim, which he has admitted he did. Now, what happened to that claim, I don't know. I think he abandoned it because I think he wasn't happy with the benefits, and he sued Sullivan County for $3 million plus $20 million in punitive damages. And that's what is before Your Honor today. And he, in his complaint, he alleged 4 counts. 1 was intentional failure to remediate contamination of property. 2, intentional concealment of biohazardous exposure, 3, fraud, intentional misrepresentation, and 4, intentional infliction of emotional distress. I filed a motion to dismiss, alleging that 2 grounds. Number 1, that this is a workers' comp claim, which the trial court agreed with me and dismissed it. But in the alternative, I argued that the county is protected by the Governmental Tort Liability Act, which intentional acts are not allowed under the Governmental Tort Liability Act. And the trial judge ruled that should this court find that it is not a workers' comp case, that he would also, his claims would be dismissed because they are claims of intentional acts, which are not allowed on the Governmental Tort Liability Act. The trial court held, quote, "This court is of the opinion that plaintiff's exclusive remedy as to the allegations in his complaint," and again, the judge found that this is not a workers' comp complaint, "is as a matter of law limited to that available under the Tennessee workers' comp law, and that the complaint in this civil action makes no claim for relief under the Tennessee workers' comp law," and accordingly, the case was dismissed. The trial court recognized a narrow exception to the exclusivity of the Tennessee workers' comp law in situations where the employer actually intended to injure the employee. However, the court ruled, stating, "Tennessee courts have held that the complaint must allege facts showing that the employer actually intended to injure the employee, and that wanton, willful, deliberate, intentional misconduct of the employer, even criminal negligence, is not enough to prove intent to injure." And there's numerous cases that support that principle of law. And the court found the complaint in this civil action makes no claim for relief under the Tennessee Workers' Comp Act. It was accordingly dismissed. And the judge also found that it made no claim of an intentional act to dismiss. As I said, the court went on to say, quote, "Should this court's ruling that the plaintiff's exclusive remedy is under the workers' comp law ultimately be found to be error, this court is also of the opinion that plaintiff's claim would be limited and subject to the rights, remedies, limitations, and immunities provided defendant under the Tennessee Governmental Tort Liability Act. This court is also of the opinion that the complaint filed in this matter states no claim under the Tennessee Governmental Tort Liability Act. Plaintiff's claim for intentional infliction of emotional distress, misrepresentation, fraud, deceit, libel, and slander are not allowed against defendant under the Governmental Tort Liability Act." Plaintiff filed his appeal, and that's what we're here on today. In my statements of the facts, I list 3 relevant facts. Number 1, plaintiff was at all times material hereto a full-time employee of defendant Sullivan County Department of Education, which he admits readily throughout his paperwork. Fact number 2, the injuries allegedly suffered by plaintiff arose out of and occurred during the course and scope of his employment with Sullivan County Board of Education. And he admits that throughout his pleadings. And number 3, the Sullivan County Department of Education is the Tennessee Sullivan County school system and a governmental entity, and thus covered by the Governmental Tort Liability Act. Plaintiff raises 4 issues. Issues 1 and 4 really are taken care of by issues 2 and 3. So we'll skip issues 1 and 4 and discuss only issues 2 and 3. Issue number 2, he says, whether defendant's level of intentional concealment, fraud, and intentional misrepresentation and breach of duty meet standards of review to qualify under the narrow exception needed to overturn the court's opinion that Tennessee workers' comp law is my exclusive remedy. As I said, employee was at all times a full-time employee. Immunity under the Tennessee workers' comp is an affirmative defense. If allegations in a complaint show that relief is barred by an affirmative defense, the complaint is subject to dismissal for failure to state a cause of action. And I've cited there most all the cases that I've cited that deal with this issue about whether or not the employer intended to injure the employee are dismissed on a failure to state a cause of action. So the law is pretty clear that defenses like this can be dismissed on a failure to state a cause of action. The workers' comp statute is very clear that it covers all claims by employees. Quote, the rights and remedies granted to an employee subject to workers' comp on account of personal injury by accident shall exclude all other rights and remedies of the employee at common law or otherwise on account of injury, TCA 50-6-108. And then, quote, pursuant to this section, Tennessee workers' comp law provides the exclusive remedy for an employee who is injured during the course and scope of his employment, meaning the employment is precluded from seeking tort damages for the injury. And I cite for that, there's numerous cases, but I cite another case that's very similar to the facts in this case, Valencia versus Freeland and Rogers versus GCA Services. And of course, occupational diseases which arise out of and in the course and scope of employment are synonymous with injury and personal injury for purposes of the Workers' Comp Act. Quote, the workers' compensation law takes away from the employee his common law rights and gives him others on the guarantee that these substituted rights shall be generously awarded, both for foregoing his common law rights and in consideration of the obligations of his employer to keep his employer from becoming a public charge. The legislature has made the rights of the employee and the employer the exclusive remedy. Those who accept benefits under an act of this kind must likewise take the burdens. And I cite cases to support that. So the point is, workers' comp, if he fits the definition of workers' comp, which he does, he was an employee and the injury occurred during the scope of his employment, then he is limited to his workers' comp claim. And he's admitted that he made a workers' comp claim. He says that they told him he had to go to court, and instead of going to court in a workers' comp claim, he filed this lawsuit for, as I said, $3 million. He can't do that. He's limited to his workers' comp claim. Now, as the trial court ruled, there is an exception under workers' comp if the employer intended to injure the employee. Well, there's nothing alleged in the complaint that the employer intended to injure the employee. And again, there's cases in my brief that say that the definition of intent in normal tort law is not what we're talking about. We're not talking about, did you intend to do what you did? It's not that type of intent, nor is foreseeability an issue, nor is the fact that it's criminal negligence, and the cases go on and on and on and on and on, and I'll cover a couple of them here in a minute. I'm about to run out of time. But there's cases in here where employers sent the employees into very unsafe work environments they knew were unsafe. There's a case in here that I refer to that talks exactly the same facts of black mold, made the employee work around black mold. There's cases where they sent the employees to use dynamite when they knew nothing about dynamite. There's a case where they removed the fiberglass insulators from an electrical cherry picking truck, and the guy got electrocuted, and the employer knew about these safety violations. There's cases where the employees are found guilty of safety violations, and the arguments are that they knew or should have known that this was going to cause death even. Several of these cases involve death, but the courts have consistently ruled that criminal negligence, gross negligence, violation of safety standards is not enough to fit the exception to come out from under workers' comp. You have to intend to harm. You can't be negligent. You can't be grossly negligent. You have to intend to hurt them. There's no allegations in the complaint that the Sullivan County Board of Education intended to harm this gentleman. In fact, the only way it could happen is if the Sullivan County Board of Education actually went on record and voted that we want to harm these people. Simply gross negligence is not enough. Not taking care of the mold, not providing a safe work environment is not sufficient to bring him from to allow him to come outside the protection that the county enjoys under the workers' comp statute. And that's the case. This is a workers' comp case. There's nothing, very clearly he was an employee and Sullivan County is entitled to the protection of the workers' comp statute. He's entitled to the benefits of the workers' comp statute. He doesn't have to prove any fault. He just has to prove the injury. He does not fit the exception, and therefore his claim is a workers' comp claim. Now, as I said, he has also made some tort claims. If this court were to find that this case is not a workers' comp case, then any claim against the Sullivan County Board of Education is covered under the Governmental Tort Liability Act. And the statutes are very clear that his allegations of that he makes of slander, outrageous conduct, fraud, intentional misrepresentation, none of those torts are allowed under the Governmental Tort Liability, none of them. Now he can proceed against individuals for that type of action, but not against the county entity. So I filed a brief in this case, and instead of just reading my brief, I think that pretty much sets forth the county's position. If you have any questions.
I hear none. Thank you. Ms. Upchurch, your rebuttal? We got a problem with
my rebuttal is simple. It is that fraud was committed against my workers' comp case. This was intentional tort. I was sickened and found the black mold that made me sick. When I reported it, they denied it. They would not admit the fact they had black mold in their school. I proved that they had black mold in their school. I had proof that doctors did this. Yes, I was working as an employee, but when you commit fraud against an insurance claim, especially when you withhold evidence in a workers' comp claim that denies ongoing medical benefits that I need. I've been paying for medical out of pocket. I've got asthma now. I'll be paying for this the rest of my life. They actually defrauded my workers' comp case. Even workers' comp agreed that fraud. What about these 7 missing pages? Shouldn't they be of interest to the court to see if there's actually what I'm saying is true, that this is non-validity, and it would show that they've committed fraud in these air tests? They've been doing this for years in their school system, knowing that this doesn't pick up black mold and telling people that there's no mold here when there is mold there. Over half their schools have tested, have complaints of mold. It's intentional tort. There's no government liabilities protections on this. There's no workers' comp. Workers' comp already told me that due to the fraud committed against me, this was no longer a workers' comp case. This was now tort. They even informed me of my statute of limitations. Why would they do that? That was because they saw the fraud committed and knew that workers' comp case was not suitable for this case. I never would have dreamed that I would be in front of this court, Your Honor, pleading this case. I went to school to help children. I went to school to be a PE teacher to help children. When I started subbing at this school, their carpentry teacher was retiring, so I went and got recertified so I could teach carpentry, so I could help children. When I got in that building and got sick, and then they wouldn't help me, they wouldn't admit the fact that they had mold in the building, they wouldn't help me, they defrauded me, they slandered my name to the students and the staff. I mean, all this stuff's intentional. It wasn't like that they had to come in and make this up. I found the mold. They came in to discover it. I told them where it was at. They couldn't find it. They had to wait on the head of maintenance to come before they could even tell me about the mold. And then they chose to cover it up. When I asked them specifically about the mold in the ceiling I'd found, they remained silent and left, and then committed fraud with this fraudulent air test and withheld information from my workers' comp. I did not get a fair workers' comp case. It was defrauded by the county. How do you, I don't know what else to tell you. I mean, I've got proof, I've got witnesses, I've got evidence. The missing pages should be subpoenaed, I think, to see what I say is true and to show that they are covering this up. I think that that any court would want to see that in any insurance fraud case that is criminal. If you commit fraud in an insurance claim, it is automatically opening up to exploratory phase of a trial just to see what's going on here. I've not received any of that. I need some due process. I mean, I have done what I did exactly what they told me to do, and they kicked me around the whole time and slandered me. They defrauded. They've actually doing these mold systems. We're hiding the death of a child in another school. They're doing these fake air tests, telling everybody there's no mold. The kids go back to school, get sick, then one dies. Then what do? They say there's no mold. Do another air test. It's fraud. It's fraud committed against me.
Thank you, Mr. Upchurch. Well, we will review this record, and we will consider this case and issue an opinion within, I can't say for sure how long, but in due course of time on this case. Okay? Thank you very much, gentlemen. Lawyers may be excused.
Thank you.
The lawyer and the pro se party may be excused.
Thank you, sir.
This honorable court is now in recess until 10 a.m.
Thank you, Mr. Ed.
Thank you.